Court does call the case, People versus Levante, Washington.
So Public Defender Natalie Pate on behalf of Washington, who is approaching the podium. Please state your name for the record, sir.
Levante, Washington.
Thank you, sir.
Thank you, Your Honor. As to the probable cause conference, we are respectfully requesting a very brief adjournment, and we do understand that Mr. Washington was asked to be in person today because of the progress report that was sent out, and we are also willing to address that one, whoever the court would like.
Why don't you go ahead and address that?
So as the court is aware, Community Corrections did send out a progress report. Mr. Washington did test positive on both 12/27 and 12/30 for cocaine. He did already send out the 12/27 sample to the lab for confirmation. We have not yet received the results from the lab one way or another. He does plan on, after court today, appearing in Community Corrections to have his most recent test sent out for confirmation from the lab. He had planned on doing that today in any event. However, as to the progress report, we're asking the court to hold it in abeyance until we get those lab confirmations back, whether or not that was a positive test. Mr. Washington does deny any use. He is here today with his mother, who I have also had the opportunity to speak with. He resides with his mother, and his mother also says she doesn't know him using. Of course, she's not with him all the time. However, Mr. Washington does deny use. That's why he sent it out to the lab. So we're just asking the court to hold this in abeyance until we get that confirmation one way or another.
And then if it comes back positive, what do you think I should do?
I would ask that that be addressed at that time.
So you just don't want me to lock him up today?
Certainly not today, Your Honor. Mr. Washington appeared knowing that that was quite frankly a possibility. He's staying on top of this, continued to test even after he did get that positive result, went to Community Corrections and paid the $30 to have that sent out.
You going to have a test today?
Yes, he's appearing. He is going to go to Community Corrections after court today to have his test from the 30th sent out, and I believe also to be tested again.
Why do I have the feeling I'm not being told the truth? I've got 2 tests back to back with cocaine. So let me ask this question. If I send you over today and I get those results immediately, is anything going to show up in your system?
No, Your Honor.
Pardon?
No, Your Honor. Like I say, I got a lot of stuff going on for myself. This is not the only. This is probably the least case that I'm worried about. I'm on GPS tether. I don't have no reason to run or no reason to not show up and come back to court.
That's all fine. I'm more worried about your use at this point.
Oh no, I don't use it at all. I'm not trying to pit everything out on the line. If we can speak privately, then I'll be able to tell you exactly what's going on, but I don't want to pit everybody on Front Street.
So, did you read over that progress report?
Me?
Yeah, because I'm getting a lot of people that are amoebas.
Yes, I did read over the progress.
They're absorbing cocaine. And I'm not sure how that happens. Young lady appears at Community Corrections, said, I smoked it around him. That must be how he's testing positive. You believe that? You believe, hold on, no. You believe that?
Yes, Your Honor.
Really?
That's the truth.
Counsel, you might want to just be quiet, because the thing I don't like a lot are people that aren't telling me the truth. Because you can go play your game anyplace else. You're not playing it here with me. Counsel approach. Anything else you want to say?
Nothing.
I'll give him one shot. You want to tell me? I mean, from what I understand, he comes over from another place. He's in our jail, gets out, and is saying he wasn't using. I got 2 tests.
I understand that, Your Honor. I would just reiterate my request to hold this in abeyance until the lab confirmation comes back one way or another, and to address it at that time. If in fact the lab confirms that it was a positive result, I would ask for that, Your Honor, and I have nothing further to add. But except that Mr. Washington, I do truly believe will be in attendance to its next future court
I'm
date.
not so much worried about his attendance. I'm worried about his using and then lying to me. That's what I'm worried about. And then getting other people wrapped up lying. You're not an amoeba. It's not going to be in your system for 6 days, at least, in this way. Anything else?
Nothing further from me, Your Honor.
I'll grant the adjournment, and maybe, I would have normally, under most circumstances, put it out 2 weeks, but I'll put it out 1 week to the 9th, 2025, 9 a.m. At this point, however, the defendant's bond is revoked. Defendant's remanded. February 13th, 2025, 10 a.m. before Judge Washington. Bond continued.
Thank you, Your Honor. I will instruct my client to contact probation department 14B.
All right.
Judge, may I have police report back?
See what you gotta do.
Judge, I thought you'd be in a little better mood tomorrow.
I am in a fine mood, thank you, Mr. Killowald. You just keep trying to spoil it. Get him out of my well.
I'm trying.
Jesus, just give him his little papers back. Go, just go. Is that your last day?
Yes, I'm out of here.
Okay, good. Now I'll be in a great mood.
Happy New Year, Judge.
And to you, Mr. Killowald. Oh no, but Pellinger's gonna come up. He's gonna just.
I would love one of my kisses to be called Your Honor. That'd be great.
Put it at the bottom.
Oh, come on.
Court calls the case, People versus Thomas Rascal. Yeah, I know what you're trying to say.
Testimony for the people. Your Honor, Alexis Plumai, Assistant Public Defender, appearing with and on behalf of Mr. Rastall, who is approaching. Could you state your name?
Thomas, right?
Thank you, sir.
And
You're requesting an adjournment?
yes, Your Honor, we are requesting an adjournment of about 2 weeks. We're still waiting for Mr. Rastall's screening to be completed with the Washtenaw County Treatment Court out of 14A4. It's been 3 weeks since he was referred, so I'm hoping an additional 2 weeks it'll be done by then.
Which court?
It's Judge Froschauer's treatment court. I think it's called Washtenaw County Treatment Court.
Okay.
And Your Honor,
You think too? Okay.
I would like to address bond if I could.
Of course you would.
So, Your Honor,
You do adjourn it, or you want to address bond, or you just want to keep talking?
can we do both?
Whatever you want to do. Go ahead.
Okay, so why don't we get the new date and then?
Okay, let's do that. Boy, she is
I'm sorry, Your
She
Honor.
is awful bossy. Probable cause conference.
Ask him.
You think 2 weeks will be enough time?
I'm in 5 weeks to get the screening done. I hope that would be.
I don't know what the holdup would be. Let's try to be, let me give you, I'll give you the 16. See where we're at.
Okay.
9 a.m. Yes, as to bond.
Your Honor, with regards to bond, I am asking the court to consider a personal bond for Mr. Rastall. His bond was revoked 3 weeks ago on December 12th for a bond violation for a positive drug test. At that hearing, Mr. Rastall took accountability for that. He came to court knowing that it was incredibly likely that he would be remanded. He's expressed to me a genuine interest in treatment court and in his sobriety going forward. He has reliable.
Counsel,
Yep.
if I were to let him out, what would be in place that would allow his sobriety to happen?
Your Honor, I mean, he would be doing the screening for treatment court. He doesn't have treatment set up, but what I was going to mention was that the reason he's requesting to be out in part is because he was scheduled for a major dental procedure on the 13th. He's afraid that if he misses that appointment, he'll lose the funding for it. He was due to have many teeth extracted and get fitted with dentures. That's something that's causing him a lot of pain. And he also states that he hasn't had access to all of his medications for his glaucoma while he's in the jail. So he would really like to get home. He has his own apartment. He's got reliable transportation, reliable contact information. He could do the screening out of custody. I understand the court's concern with regards to not having treatment set up yet, but again, just asking the court to consider a personal bond.
We already did that though, didn't we?
Yes.
And that didn't work too well.
Yeah.
Response?
Your Honor, we were here on the 12th, and defense counsel asked for early treatment at that time, and the court wanted the defendant to be screened first. And I think that makes a lot of sense. Unfortunately, with the variety of substances, don't know that we can have testing to ensure public safety and people's minds. I would say that when Mr. Grouse is screened by Mr. T, which I think I'm surprised it's not already been done, frankly, because he's very quick, especially when he knows people are in custody, which you did know at the last time you were here, I believe, if I recall correctly. If he screens Mr. Rassel and want to get a stip in order together for residential treatment or inpatient treatment, the people would be very happy to consider at that time a stipulation.
I'm trying to get outpatient.
All right.
Understood, Your Honor.
All right. So motion for bond reductions tonight. Bond will continue.
This courtroom moment begins quietly, but ends with a man walking straight back into custody. Levante Washington stands before the judge, hoping for one simple thing: time. His defense attorney explains that 2 recent drug tests came back positive for cocaine, but she insists the results are still being sent to the lab for confirmation. She asks the court for a short adjournment, arguing that Mr. Washington denies using any drugs and even paid out of pocket to have the samples tested again. Beside him sits his mother. She tells the court she has never seen her son using drugs. She believes him, and for a brief moment, it feels like the court might believe him too. But the judge doesn't hide her concern. 2 tests. 2 separate dates, both positive. She looks directly at Mr. Washington and asks the one question that instantly changes the entire mood of the room. If I send you to testing today, will anything show up in your system? Washington answers quickly. No, he insists he has not used drugs. He explains that he is on a GPS tether, has no reason to run, and no reason to break the rules. He says this case is the least of his worries, and claims he has much bigger things going on in his life. Then something unexpected happens. He asks the judge if they can speak privately. He says there are things he doesn't want to say in front of everyone. The courtroom goes silent, and that silence speaks louder than anything else. The judge isn't convinced. She explains that cocaine does not simply appear in someone's system by accident. She directly challenges the claim that he could have tested positive just because someone smoked around him. Her voice becomes firm, controlled, unmovable. She tells him very clearly that she does not tolerate dishonesty in her courtroom. You can play games anywhere else, she says, but not here. Washington tries once more to explain himself, but the damage is already done. The judge's concern is no longer about court appearances. It is about behavior. It is about substance abuse. And most importantly, it is about lying. She makes it clear that what troubles her the most is not just the drug use, but dragging other people into the story to avoid responsibility. In one decisive moment, the judge grants the short adjournment. but immediately follows it with a crushing ruling. Washington's bond is revoked. He is remanded into custody. The courtroom atmosphere shifts instantly. What began as a hopeful request for patience becomes a painful reminder that trust in court is fragile, and once it cracks, it rarely repairs itself. For Washington, this is not just a legal setback, it is a personal one. His mother watches quietly as her son is ordered back into jail, still insisting he told the truth. While the court makes it clear it no longer believes him, the hearing moves on quickly. Another defendant steps forward. Another life, another struggle. This time it is Thomas Russell. He's also fighting addiction, also fighting the system, and also asking the court for a chance. His attorney requests a short delay while waiting for a screening for a treatment court program. She explains that Russell wants help, wants sobriety, and wants to enter recovery instead of continuing a cycle of jail and relapse. She then asks for a personal bond. And for a moment, the courtroom feels different, more hopeful, more human. She explains that Russell has a serious dental procedure scheduled, multiple teeth extraction and dentures. Missing the appointment could mean losing funding entirely. She also tells the judge he has glaucoma and has not been receiving all of his medication while in custody. Pain, health, addiction, all colliding inside one quiet courtroom. But the judge does not forget the past. Russell's bond was already revoked once for a failed drug test. And when trust has already been broken, second chances become much harder to earn. The judge listens, she considers, and then delivers a calm but firm decision. No bond reduction, no release today. The screening must happen first. The court cannot gamble with public safety, even when the story sounds sincere. And just like that, the message of the day becomes unmistakably clear. In this courtroom, intentions are not enough. Promises are not enough. Only proof matters. 2 men, 2 addiction struggles, 2 very human stories, and one harsh reality. When the court believes you are not being honest, freedom disappears fast. If you believe second chances should come with real accountability and real support for people battling addiction, make sure you like this video, subscribe to the channel, and share this story with someone who needs to see how quickly trust can change everything inside a courtroom.